Ladies and gentlemen, welcome back to Bank Rakyat's International Islamic Banking Conference 2013. We trust that you enjoyed the refreshments and are looking forward to this session. Ladies and gentlemen, our first session, which will take us up to the lunch break, will consist of two presentations, and we'll also have two discussants. The first presentation, entitled "The Current Banking Regulation and Its Impact Towards a Better Islamic Banking," shall be presented by Dr. Aida Uthman, a director at ZI Sharia. And the second paper shall be presented by Associate Professor Dr. Siti Farida Abdul Jabbar from the Faculty of Economics and Management at the National University of Malaysia. Her paper is entitled "The Implementation of Islamic Banking in the Light of Maqasid al-Sharia, Regulatory Impact." Our discussants for this session are both from the Sharia Advisory Council of Bank Negara Malaysia. Firstly, Associate Professor Dr. Rusni Hassan, also an academic at the International Islamic University of Malaysia. And secondly, Ustaz Burhanuddin Luqman, a researcher at ISRA. Our moderator for this session is Mr. Muhammad Zakaria Uthman, Assistant General Manager at the Group CEO's Office at RAM Holdings Berhad. He also represents the Malaysian Institute of Accounting at the Accounting and Auditing Organization of Islamic Financial Institutions, that is IOFI. And he is also a member of the Association of Chartered Accountants in the UK. So without any further ado, the moderator, presenters, and discussants, please take the stage. Thank you very much.
Bismillah ar-Rahman ar-Rahim. Alhamdulillah Rabbil Alameen wa salatu wa salam ashrafil anbiya wal mursaleen wa ala alihi wa sahbihi ajma'in. Distinguished guests, ladies and gentlemen, Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back. Islamic finance, or in precise, Islamic banking is growing almost everywhere. It has moved from a mere conceptual theory up to the practical reality. Of course, the natural consequence of this progress, therefore, will expose this industry into challenges. Challenges including those new as well as old, or rather reformulated challenges. Well, there are challenges in terms of intellectual, in terms of refinement of the regulations based on the maslahah as a roof, as well as the application, as well as the practicality of such industry. We are fortunate today to have with us Dr. Aida Uthman from ZI Sharia to discuss on the current banking regulation and its impact towards a better Islamic banking. Allow me to briefly introduce Dr. Aida. Dr. Aida Uthman is a partner of Zaid Ibrahim & Co. She's also a director of ZICO Law Sharia Advisory Services in Berhad. Dr. Aida specializes in Islamic banking and finance, Islamic capital market instruments, and takaful products and operations. She also advises on Sharia compliance and governance, including on the legal and regulatory framework for Islamic finance. Without further ado, please welcome Dr. Aida.
Bismillahirrahmanirrahim. Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh, and a very good morning, everyone. I would like to thank the organizers for inviting me to this session this morning, and also for the attendees. I saw that it was an impressive number that was registered outside for making the time to participate in this two-day discourse. I work as a partner at a law firm based in Kuala Lumpur, and I'm also involved in doing some Sharia advisory work. And this morning, I've been invited to discuss 2 points provided by the organizers, and they are: does the new Islamic Financial Services Act, which came into force in 30th of June 2013, support the Islamic banking implementation in meeting Maqasid al-Sharia, and what are the proposed amendments to the current regulations to achieve maqasid al-Sharia. Lately, there has been some very deep discussions among contemporary scholars, both in Malaysia and also outside, as to this concept called maqasid al-Sharia, or if we can translate it as the objectives of the Sharia. If you are a student of usul al-fiqh, you will encounter concepts very closely related to a discussion of the maqasid al-Sharia. For example, the concept of maslahah, which is public interest. I will go very briefly through these discussions from classical sources as well as contemporary sources, just as a precursor to our discussion today. It is very well known, writing of the illustrious Imam al-Ghazali, when he says the objective of the Sharia is to promote the well-being of all mankind, which lies in safeguarding their faith, their human self, their intellect, their lineage, and their wealth. Whatever ensures the safeguard of these five is maslahah, good, and whatever denies these essentials or prevents or takes them away is mafsadah, evil, and to prevent this is maslahah, good. And from this, the jurists and the scholars deduce that any act, any law, any policy that safeguards these objectives of the Sharia are good and should be promoted. Ibn Ashur defined the maqasid of the Sharia as the deeper meanings and inner aspects of wisdom considered by the lawgiver in all or most areas and circumstances of legislation, ahwal al-tashri'. He also explained the importance of the knowledge of maqasid al-Sharia for the mujtahids, not only in understanding and interpreting the text of the Sharia, but also to find solutions to the new problems facing Muslims on which those texts are silent. So this is a summary made by a contemporary scholar as to the writings of Ibn Ashur. And it is from this premise, because Islamic law, in addition to family law or personal law, is being implemented today in the field of Islamic banking and finance. Scholars are saying we are formulating ahkam, rules, doing ijtihad on a consistent basis. So we want to look if our efforts could be informed by looking at the maqasid al-Sharia, if we are on the right track. By Allal al-Fasi, he says, the overall objective of the Sharia is to make the earth flourish with civilization, to maintain the system of collective livelihood upon it, to maintain the system of collective livelihood upon it, and to sustain its goodness by making good those who are placed upon it, to sustain its goodness by making good those who are placed upon it to carry out God's will. So this is us, the human beings, so that they will accomplish the duty assigned to them of establishing justice and integrity, properly developing and using the intellect, improving the world, discovering and extracting its resources, and administrating all that for the benefit of everyone. Okay? So the objective of the Sharia is to get us to play our role, to get us not to transgress, to put us in a certain path, okay, to regulate human beings. That's how I deduct it. Al-Shatibi saw the maqasid al-Sharia not merely as the embodiment of the lawgiver's intent and the goals for which he instituted the legislation enshrined in the Quran and the Sunnah, but as the philosophy that should shape the epistemological structure and methodology of Islamic jurisprudence if an effectively creative and productive practice of ijtihad were ever to be achieved. So even though classically the concept of and the role of maqasid al-Sharia were not fully systematically, structurally structured the way contemporary jurists attempt it today because of the challenges faced in Islamic banking and finance, these are some of the thoughts that are triggering becoming the catalyst for the discourses that we are seeing today, including these 2 days. So contemporary scholars are discussing how the theory of maqasid al-sharia could guide the process of ijtihad in the endeavor to solve issues innovatively while complying with the will of Allah subhanahu wa ta'ala, the lawgiver. The search for and protection of the maqasid al-sharia already underlie the concepts well known in Islamic jurisprudence, where jurists looked for reasons behind rulings and ahkam and the texts themselves. Scholars now are attempting to rejuvenate and reform the process of ijtihad today by bringing to the forefront the need to consider the wider universal objectives of the maqasid, as they are concerned if preoccupation with a literalist and textualist methodology influenced by the values of medieval society dominates ijtihad today at the expense of the well-known maqasid that we have explained, especially the main 5, and solutions that genuinely ensure human well-being, which is the overarching objective of the maqasid al-sharia. Islamic banking and finance is an area in which Islamic law is being applied and formulated anew on a daily basis today, thanks to a rapid growth rate, and scholars are examining how the theory of maqasid could inform the sharia rulings by jurists and legislations by the ulil amr. So policies and laws by rulers, regulatory authorities, by right, should also reflect the concerns and the objectives of the Sharia. Applicable to this field based on solid foundations and firm principles. Now, the scholarly discourse has reached a certain level. Based on the presentations that we could see, we could read and follow, they no longer feel that we could simply quote, this is the maqasid al-sharia, this is maslaha, and therefore, we rule this way. We allow this or we prohibit that. So they felt that this is too general to be helpful. It is not based on solid jurisprudential foundations, and they are trying to build a more solid juristic foundation for this discourse. And they hope that this will help Sharia advisors, jurists today, Sharia committees, Sharia advisory councils, regulatory authorities to issue rulings taking into account these principles and lead to what they feel more enlightened rulings and policies to guide the industry. There are discussions by jurists as to what we call the general objectives, maqasid ammah, the broader overarching ones, and they were the ones that I discussed just now. Some scholars add to it. They will say we have to add to protection of life, wealth, and so on, new elements. Let's see, if I'm not mistaken, it was growth, for example. So it's not just about preserving existing wealth, but to promote growth and greater prosperity. Then they also say that there are specific objectives under each of the broader maqasid ammah, those 5 or 6 objectives. There are more specific ones that will guide our study. These broad and specific maqasid, they could overlap and they could, relate to each other. And they also talk about what are the paths, the ways, the means to achieve the specific objectives or the broader objectives. They call it the wasail, the mukammilat. And this is what we will be discussing today. How the new law, the IFSA, if it takes into account, if it reflects the broader objectives of the Sharia, the specific objectives under each of the broad maqasid, and also if they incorporate some of the wasail and mukammilat that reach to these objectives. So these are some of the ways that we could analyze a particular piece of law or policy or ruling. Based on the discussions with people who have reviewed this new law, there are some areas that people are uncomfortable with. And so in the discussions by jurists, they will say they wonder whether if some wasail and mukamilat, which are merely permissible, if they could be made obligatory on the citizens, okay? Which could normally entail a required objective, for example, to establish an Islamic bank to cater for the needs of the Muslim community or to require registration of marriage and so on. So there are a couple of areas which some people wonder about. A consideration of possible consequences in determining the ruling of certain acts or transactions in the framework of the maqasid and their wasail will provide a scale of priorities of actions and put a balance between the maslaha and the mafsada. So this is a quotation from one of the contemporary jurists today who is studying this field. So if we look at the Islamic Financial Services Act, this is an act regulating the sphere of banking and finance. The relevant maqsad would be the preservation of wealth. If we look at the well-known maqasid of the Sharia, the most relevant one would be this, although the other objectives could also be, related, applicable. So under the specific maqasid under preservation of wealth, jurists talk about ensuring, safeguarding circulation. They talk about safeguarding clarity. They talk about preservation and protection. And they talk about stability and proof. And they talk about achieving justice. And some scholars will add fulfillment of human needs and growth and development. So under circulation, it would mean safeguarding or making sure it is available, movement of goods and services in the market, and their widest possible distribution among the people. For example, through trade, investment activities, work and professions, and possibly through zakat as well. If we look at clarity, the jurists elaborated as safeguarding wealth from ambiguity and confusion in the ownership of property in order to avoid conflict among the people. It is protected by clarity in its modes of acquisition and transfer through contracts and iltizam, and protected against unfounded claims through documentation, witnessing, guarantees, and means of proof. Okay? And it could be protected by laws that are very clear as to the rights and obligations between stakeholders in the industry, for example. Preservation is to protecting wealth by putting various rules of, by laws to protect property, laws preventing from theft, fraud, deceptive practices, and so on, from robbery, from usurpation. Okay? This can come under this category. Stability and proof, according to the jurists who discuss it, means firm and established stability in the preservation of wealth is ascertained through a regime of law, contracts, and transactions that ascertain a stable environment of ownership, exchange and transfer of goods and services among people. Okay? People are assured of the continuity of their rights. Justice, this specific objective is to safeguard justice and fairness. The Quran says that the trade must be based on mutual consent. Do not do dealings by batil, for example. The property must be acquired or generated in a manner that is just, not wrongful or oppressive on others. You can have an Islamic, let's say a partnership. You can have a musharaka or mudarabah contract with terms that could be unfair or inequitable to one party, okay, for example. It also entails a safeguarding of public interests and preventing harm from them. For example, ensuring that people can access sources of water, public spaces, for example. This would come under this category. Now let's look at the objectives of the Islamic finance industry that is espoused by, let's say, the promulgators of the international standards for Islamic finance, for example, regulatory authorities, and people who promote it themselves, other players and stakeholders. The main impetus for it coming into existence is to provide services that fulfill the financial needs of Muslim communities. Okay? So Muslims want to, they are able to purchase a house, but they avoid doing so and continue to rent, for example, because they say we do not want to be involved in conventional ways of purchasing a home or a car, for example. Or they would keep their money under their pillows. This still, in many communities, this still happens. For example, in the North African countries, let's say, where they say, we are not going to, we know it's more secure to have a bank account, etc., but we're not going to be involved in the conventional banking system. So this is to ensure that they're able to keep money, save money, protect their money, get financing, secure their monies or jewelry, for example, in a certain manner that does not breach their convictions, their faith. This is a great service. Is the impetus and catalyst for the industry, maybe about 40, 50 years ago. Ensuring Sharia compliance in the industry to prevent breaching of the laws of the lawgiver and to uphold its credibility. I mean, Sharia compliance is the reason why this industry came into existence in the first place. And now the reason why people go to an Islamic bank, go to an Islamic fund manager, because they say, I will be able to do so in a compliant manner. I will not be breaching God's laws, and there will be blessing in my supporting the industry. That's why I go to them. And I will invest my money with this fund manager because they will not invest it in industries which are haram, and the income will be pure, and they will manage this in a certain way. And I'm contributing to the community. So when this is jeopardized, when you no longer have credibility in the Sharia compliance of the industry, this is when its future, when its credibility, its integrity, and sustainability will be affected. So, for example, if you look at the Islamic Financial Services Board, which issues various standards for Islamic finance, they say this is why, besides the financial repercussions, you will have to channel and, not recognize these amounts which came through by way of non-compliant methods. It is very important for the long term. The effort has been made to create this industry that you have to make it sustainable. It has to be successful. You must not let it be impaired by these accusations that we take Sharia compliance for granted. These two objectives are, of course, in line with the maqasid. Right now, if you look at now they are talking about expanding this beyond the hubs, beyond the places which are already successful with breadth and depth of products, institutions, and so on. We want it to spread. We would like there to be global linkages and connections, more cross-border transactions, and hopefully there'll be more Islamic finance institutions opened up in countries which do not know of these institutions. This is one of the, let's say, the Malaysian regulatory authorities. This is one of the ways that they think Islamic finance ought to go. And this is in line with the maqasid al-Sharia to spread and ensure that the implementation of God's laws is as widespread as possible and enabling as possible for many people to access financial services. So, prominent contemporary Islamic economists subscribe to the view that Islamic banking and finance is a subset of the overall Islamic economic system that strives for a just and balanced society as envisioned in the maqasid al-Sharia. Justice is an overriding objective of the Sharia, in the category of maqasid ammah that permeates all aspects and areas of Sharia beyond technicalities and procedures. That's what jurists are aiming for. So let's look at the law. this is the view of senior lawyers who have analyzed the law. They say this is a step jump in the regulatory and supervisory framework for banking in Malaysia, including in Islamic banking and finance. It is the culmination of efforts to, and this is a description of Bank Negara itself as to this new law when it first announced it. Bank Negara says we need to modernize the laws that govern the conduct and supervision of financial institutions in Malaysia to ensure that these laws continue to be relevant and effective to maintain financial stability. One of the things that pushed them to speed up the coming into force of this law are global developments. They would like the regulatory authorities in Malaysia to be ready to face any hint of any problem that had occurred in the global financial crisis. Quite a lot of people disagree and they say it's just the Western financial crisis, you know. But Bank Negara say we need to be prepared. Bank Negara wants to support inclusive growth in the financial system and the economy, provide adequate protection for consumers, provide Bank Negara with the necessary regulatory and supervisory oversight powers to take preemptive measures to address issues of concern within financial institutions that may affect the interests of depositors and policyholders and the effective and efficient functioning of financial intermediation. So this is a gradual shift away from the self-regulatory approach of the previous regime towards one of increased regulation and corporate accountability. Both laws, the Conventional Financial Services Act and the Islamic Financial Services Act declared the objectives very clear from the outset. So for the IFSA, there are two objectives. For the Conventional Act, there is only one objective. The Conventional Act says the purpose of this new set of laws is to promote financial stability. Yeah? Is this in line with the Maqasid al-Sharia? Yes, it is, you know. And this is the wasail provided by the laws. In this respect, it is similar with the IFSA. Okay? This is the first objective of the IFSA. It's the same with the Conventional Act, to promote financial stability. And this, the laws attempt to do by promoting safety and soundness of the financial institutions, promoting integrity and orderly functioning of the money market and foreign exchange market, safe, efficient, and reliable payment systems and payment instruments, fair, responsible business conduct of financial institutions, protect the rights and interests of consumers. For the Islamic Act, the additional objective is to promote compliance with the Sharia. This is what it says, to promote compliance with the Sharia as the reason for the existence of the industry, and to uphold the credibility of the industry and to ensure its sustainability and continued success. This act is said to be the most stringent, you know, if you compare with any jurisdiction at all in the world, because it contains a statutory duty of Islamic financial institutions to manage Sharia risks. So when we say statutory duty, means it requires by law for you to do it. It's embedded in law, not just a Bank Negara regulation anymore. To manage Sharia risks, and they will outline how you manage it, and you must ensure Sharia compliance in all your activities and operations at all times. It also it clarified a position that people already know, but it says it very clearly this time that we are the Sharia regulator. Yeah? With advice from the Sharia Advisory Council, of course. We will be issuing Sharia standards. We will issue standards on pure Sharia issues. We will issue standards on Sharia governance framework, and we will issue, this third category, they call it, any standard that is required to achieve Sharia compliance. This is a very broad category. And this act actually incorporates directly some of the decisions of the Sharia Advisory Council into law. It does not just remain in the published SEC resolutions anymore, they embedded it in the law. Strengthening of Sharia governance requirements the Sharia audit, if they perhaps if they do not really like the way institutions do it, or if they think there are issues or circumstances that merit it, they will require that an institution will appoint an external Sharia auditor. And in addition to that, they could also appoint one, Bank Negara itself, but the institution will have to bear the expenses of both. As you know, Sharia audit is the final, you can say the final line of defense when it comes to managing Sharia risk. So they take Sharia audit very seriously. And they also incorporated in law, they did not let it remain just inside a Sharia governance framework, which has become a standard under this new law. They declare that all Bank Negara guidelines now become a standard under this law. You must never breach it, you cannot breach it. They incorporate the requirement that the Sharia committee must receive all the information it requires for Sharia decision making. This is considered very important. Many discourses around the globe and even in Malaysia, Sharia scholars say one of the main challenges of their work is to sometimes, they say if we had received information Y or if we had seen X, maybe our decision would have been different. So after some years, Bank Negara decided to put this requirement into the main law. And it also adds, both laws really add to the requirements of directors. In addition to their duties under the Companies Act of Malaysia, financial institutions are companies, they add extra responsibilities for the board of directors. They are already responsible for Sharia governance framework, if you look at the existing guideline, but it says, there's a new provision that says board of directors must give due regard to the decisions of the Sharia committee. Can't put them aside, you know. They're not like one black box in the corner. They don't know directors don't know them. You must really take seriously the Sharia committee and implement their decisions. Consumer protection, there's a whole schedule just about prohibited business conduct. No coercing, no undue pressure. There is also a schedule whereby, for example, it is harder for financial institutions now to void contracts on the basis of, for example, certain lack of information. There is a requirement in the law that says that for insurance and takaful operators, you must think very carefully of the questions you want to ask at the pre-contractual stage. If you do not ask them, then you have waived it. You can't simply void it later. For example, for this lack of information. So there is a lot of provisions in favor of consumers as well. Serious penalties for breach. If you breach any of the provisions of the Act, the penalties can be very, very severe. So for example, if there is a breach of Sharia principles, and they say you breach Sharia principles by breaching, let's say, Bank Negara SEC resolution or the decision of the Sharia committee, and you did not follow the proper procedure laid out in the Act to report within a certain time and so on, come up with a rectification measure, any person could be liable for very serious penalties, and they could be 8 years imprisonment or up to 25 million fine, or both. So there are a number of serious penalties for other breaches in the Act as well, and this quite a number of people found quite surprising. I've given here some of the summary, if any of you who are interested, some of the salient new provisions in the Act. There is greater clarity in the law about role of Bank Negara, role of Islamic financial institutions, who is going to be authorized and licensed, there are institutions that the Bank Negara could prescribe as coming within their jurisdiction if they feel that such an institution could pose a risk to financial stability. So this is an extension of Bank Negara powers. Now they introduce rules, very strict rules on financial holding companies because they want to monitor the group activities. Parent companies now can't simply have activities in other than financial services. So they regulate financial holding companies, increase directors' duties. Explicitly, this law says that, for example, the board of directors of a licensed takaful operator shall, in the event of conflict between the interests of the takaful participants and the shareholders, give priority to the interests of the takaful participants. Yeah? Strict liability on directors and senior management as well. This act sort of reverses the presumption of innocence. It says that there is strict liability when several things happen, including Sharia compliance issues. If they find that there is a breach of provisions related to Sharia compliance, you don't need knowledge, you don't need intention. It's like strict liability. You'll be found to be liable unless there are two conditions that they must fulfill. They must have, demonstrated due diligence in preventing it from happening. And delegation of responsibility is not a defense anymore. By way of a conclusion, in my view, the stated policies of Bank Negara and the objectives of the IFSA are harmonious with the Maqasid al-Sharia. Let's say if we look for preservation and protection of wealth and the entitlements of human beings to wealth and their assets, there are mechanisms in there that uphold it. Also, the IFSA reflects the provisions of international standards, such as those of the IFSB and AUFI, which are based on the Sharia anyway. So, for example, when IFSB 10, the standards on Sharia governance framework was issued, not long after that, Bank Negara immediately incorporated them into the Malaysian laws. So due to this comprehensiveness, I'm not sure, based on the question, whether further regulations are needed. It's quite detailed, but the question is, how will are the Islamic financial institutions able and ready to implement them? And will they be enforced by Bank Negara? If there are additional regulations, the necessary ones are already there. If we look at Daruriyat or the Hajiyat ones, if you want to look at those that will refine it further, one of the questions that has been posed by Sharia committee members, there is so much non-permissible amounts, impure amounts that are being channeled by Islamic financial institutions and Islamic fund managers every year, millions and millions of them. So beyond the thousands of suraus that have benefited 5,000 each every year, can we do something smarter and more innovative to tackle a problem of the Muslim community? And this would help to achieve the objectives of the Sharia, the way that some well-known foundations handle and tackle philanthropic activities. So thank you again for your attention. Assalamu alaikum warahmatullah.
Thank you, Dr. Aida, for giving a very detailed explanation of Maqasid al-Sharia. Because more often than not, people like me, the practitioners, tend to use Maqasid al-Sharia without being able to explain in detail. More often than not, when asked what is Maqasid al-Sharia, or is the objective of Sharia, what is it actually, we can't really relate it. And in fact, interestingly, Dr. Aida has also related with the enforcement of the Islamic Financial Services Act in relation to the Maqasid al-Sharia. Okay, before we move on to the second paper, I would like to invite Associate Professor Dr. Rusni Hassan to comment on the paper presented by, to comment on the paper by Dr. Aida. A little bit background of Dr. Rusni. She's basically a lecturer at the Islamic Law Department of Ahmad Ibrahim Kuliah of International Islamic University of Malaysia. She is a member of the Sharia Advisory Council of BNM. In fact, she's one of those people who will basically decide who will basically provide the decision in terms of regulating the Sharia. And she's also the Sharia advisor registered with the Securities Commission of Malaysia. On that note, please welcome Dr. Rusni.
Thank you very much. It's a slight change of the, I'm not sure because I thought I'm going to comment for both, but it's okay, okay. I've browsed through the, what we call it, the paper by Dr. Aida and Dr. Farida, in fact. It was given to me last night, if I'm not mistaken. Okay, and then I think both talks about a very interesting point of regulatory framework and the maqasid. Dr. Aida just now have gone through a detailed explanation of the maqasid. And, you know, this morning I decided then a few slides maybe can help in terms of, you know, making the discussion more interesting. Okay, and then other than that, I think maybe, I hope that you are not frustrated having me here because I'm substituting Dr. Aznan, okay? And then you can expect that I'm as good as the original, which is Dr. Aznan, of course, that far and beyond my, you know. Okay, but given the task then, okay, I'm going to go through some of the aspects which have been mentioned by Dr. Aida and focusing on the regulatory framework of Islamic banking and finance. I'm going to start with a simple glimpse of history of what is what the Malaysian experience, I would say, on Islamic banking and finance regulatory framework. When we started Islamic banking and finance way back 1983, okay, the way how our regulatory framework was very humble, I would say, okay, because those were at a time when we started introducing Islamic banking, we must have certain regulatory framework. The thinking of the regulator at that point of time, the drafters of the regulation, that have it be in a simple Islamic Banking Act and the Takaful Act, and then let's see how it works, how it goes, right? That is the reason why IBA and Takaful Act, the TA was very slim. There are quite, you know, few, what we call it, pages, and then the rest, we said that let's refer to the conventional side of it, and let's see how it works, okay? Throughout the way then, however, we find there are quite a number of conflicting things, okay? And therefore, we started doing a lot of, I would say, amendment in our law. We start amending the IBA, we start amending the conventional, the relevant law on the conventional banking and finance, such as BAFIAM. We also amend in terms of the taxation law, Stamping Act, as well as the Property Gains Tax Act and whatnot, and a few others. And those also were the days, okay, after, I would say, the second stage, okay, and then I go for 10 years of the development, of which we start thinking about harmonization of the law, okay? And that at that point of time, by this amendment given to our regulatory framework, we have more players coming into the picture. We have windows. But having the windows, then we have another problem, of which we can't, in a way, control the mixing of fund, which is clean and not, and then whatnot, and Bank Negara start coming out with the details guidelines, okay, on how to operate Islamic banking, okay, for full-fledged Islamic bank by virtue of IBA and the Takaful Act, at the same time controlling or giving the supervision to the banking windows, okay. We decided the second stage is of which we go more players, and therefore we start looking at Islamic capital market, okay, being the friends and colleague to the Islamic banking, and therefore there's a need for much bigger, what we call it, market for Islamic finance. Moving on, 2000, we move on 2000, to me, I'm amazed with the development of the law. We are very serious about law harmonization committee, okay? And then we have good people, there's a lot of sessions, okay, with the regulators and whatnot. We at the commission level are given a huge task of looking into certain specific law, whether all these laws are compliant with the Sharia and Islamic finance. We started with simple contract act, okay? And then there are sessions that we do have with the AG and whatnot. Again, the purpose is that to make sure that our regulatory framework supports Islamic finance. And this is an amazing, the development, okay? And being the parties that have been very close to the Islamic banking and finance, I can say that this is not easily achievable if you don't have a good commitment and a good support from the regulatory authority, from the government, from the practitioners. It needs all these people, okay? Because every time to the practitioners, to the bankers, a new law coming in, you kind of, wow, this is a new thing that we need to do. What more when move on to now, the third, I would say that the fourth phase, 2010 onwards, of which, wow, we talk about IFSA. The first time when IFSA was introduced, and then, we keep on getting a lot of calls from the practitioners, from the bankers. What are you expecting us to do? Are you talking about revamping all the financial intermediary, and we do what? Okay? Everything, the new law come in, the expectation was like, wow, it's a big thing, we need to do something. But it's good in the sense that all parties are fully aware of what the law is, rather than, I would say, look at the law and then let's continue whatever we are doing. Okay? So the 2000 to me is the open up, of which we'll go into details on the governance. Starting with the, what we call it, previously we have Garis Panduan Syariah. It was there, but in terms of implementation of Sharia compliance and governance, I would say we are not at a very good level. The manual is not there and whatnot. And then we are thinking that if we are really serious about Islamic finance, we can't do that. So the fourth phase, okay, in the Malaysian development of regulatory framework, of which we said that we walk the talk. We do exactly what we want to do, that is to achieve Islamic finance. And believe me, if you really understand what Islamic finance, the objective and whatnot, this is why we are moving towards this. So why then, a kind of very negative, what we call it, perception towards IFSA, I would say. Yes, I'm not saying that IFSA is perfect. We have yet to see, but the objective is very good. Looking through what IFSA is all about, I think, well, it poses a good challenge, a huge challenge to all of us, not only practitioners, even the regulators. The first thing that I have in mind that I was thinking is that, are you really sure Bank Negara has all the infrastructure to ensure enforcement? Because it's a huge thing. But, this is something that we have to do, something we can't avoid. So we must take up the challenge moving forward, okay? This is the fourth decade already. And it's time for us to really serious about what we want to do, okay? So we move on and we look into what we call it Islamic banking in terms of IFSA particularly. I'm interested to quote what Dr. Aida mentioned just now, looking into section 6 of IFSA. Very interesting, okay? The principal regulatory objective of this law is financial stability and Sharia compliance. What else we want? If we are the promoters of Islamic finance, we want to have Sharia compliance, right? Why are we having a meeting? Why are we, whatever it is, the Sharia committee, are forced anyhow to understand the technicalities of banking, okay? And then they are forced to see it in the board meeting without really understanding what is there, because corporate governance to the Sharia committee is something that's beyond them to some, okay? But we need to understand what is it. I'm giving a simple example to me, legal and Sharia background. The first time I was introduced to the banking, I'm not really aware what is credit and debit. Sorry. And then when they say credit debit, can you explain what is credit debit to me? Because to us, accounting, economy is beyond us. But now, Sharia committee have to understand all this. We need to go attend the classes, sessions for working, for trainings and whatnot. Do you really, I attended accounting class and then I was looking at the lecturer, not even understand what the lecturer is talking about. But we need to do that. Okay, this we are talking, so at least whenever this accounting, what we call it, statement, what we call it, table to us, we said, oh yeah, I know that what we call it stand for. This is what we are looking at, okay? Now, moving on, okay, to other things which is also mentioned and also interests me a lot, that consumer protection. Throughout the way, when we have the first phase, the second phase, fourth decade, only now regulatory framework on Islamic finance are now talking seriously about consumer protection. All the way along, the industry, the regulator are so occupied on how to get things, sorry to say, compliant with the FIC requirement. With the FIC requirement of what bank are operating. We are still struggling with how BBA should be done, the execution part, okay? I think all of us are fully aware recently we are talking about interconditionality. How on earth, after 30 years almost of we are doing BBA, and then we started to realize, our BBA, the way how we did BBA was wrong all the way along. It doesn't make sense. The resolution of SAC was years back. Why then? It was not properly implemented at the industry level. As simple as that. We have the answer to that is total and full enforcement of what the law is. And now we are saying that, guys, whatever you do, you have to always refer to your SC decision and also SAC decision. And SC, Sharia Committee, whenever you approve, it's not just mere signing of the paper, but it must go through full deliberation of all aspects. And industry, bankers, whenever you deliberate matters, you bring up the matters with the Sharia Committee, make sure, don't hide things. Don't put something behind the cupboard, don't put something, under the carpet and whatnot. Just tell everything. And thus, it gives another challenge to the Sharia Committee. The Sharia Committee must have a good knowledge so that he or she would be able to ask the right question in the meeting. Because if I do not know about accounting, I wouldn't be able to give a correct, what we call it, questions on what are you talking about. I just look at the number and that's it. Okay, approve. Okay, so we are not talking about that. And therefore, the enforcement of the penalties. Now, coming back to the point, on this point, that I'm interested to see how fair and responsible Islamic banking moving forward. There's some question just now that talking about BBA for abandoned project. I would say, okay, after the evaluation of full enforcement of 10 years, for example, of IFSA, looking into the context of fair and responsible business, I would say shouldn't be having such a problem anymore. I'm not saying here that I'm on or behalf of whatever it is, but it shouldn't be, because we look in the context that it is good and fair to both parties, bankers as well as the consumer. Consumer must be fully protected. So far, we are very focused on what we are doing on our product, operations and whatnot. We don't really think about consumer. Now, moving forward, consumer shall always be us. Because it's true, every time I attended banks meeting, my thinking, I'm the banker. Okay? But when I go back to the what we call it, to the school, and then talking about Islamic banking, and then we got the feedback from the consumer start asking. And then I start thinking, I'm also the consumer on another perspective. This is not, we don't really mix it up. And I'm hoping, we are looking forward for more better consumer-friendly products in future. Okay? Last but not least, okay, on the enforcement of penalties of everyone. Okay? So, regardless of who we are, basically, if we are stakeholders to Islamic finance. And therefore, well, Bank Negara, again, have a lot of power, okay, in terms of oversight, okay, to ensure oversight functions of Bank Negara in terms of the enforcement of. One way is that to ensure enforcement is that we, in a way, IFSA always been seen as a threat by, threatening that if you don't perform well, you shall be punished. Okay? And the favorite questions whenever I talk about IFSA in many trainings and sessions, they said, who's going to be in prison? CEO, Sharia Committee, or what? Okay? So they talk about that. Actually, IFSA is not as cruel in that manner. Bank Negara, before what we call it, imposing the criminal offences, okay, by putting someone into prison, should be taking a normal, what we call it, stages of what we call it, advisors. Definitely, they're going to start with investigation, okay, and then taking the administrative action whenever necessary by imposing certain penalty on any parties that were not performing their job well, okay, and then possibility of taking the civil actions, and then you will resort to criminal. Okay, so it's not easy to just, okay, something wrong, consumer complaint, and therefore we take the CEO into the behind bar. It's not that way. And this is also including the Sharia Committee. So, representing Asas, of course, one of very big concern for the Sharia Committee is that, wow, how can we pay 1 million individual personal indemnity for any Sharia Committee who do not, who are not compliant with the IFSAs, and then therefore 1 million will be, okay? So where are we getting the 1 million? Okay? At the end of the day, some of them say that I'm not going to be the Sharia Committee anymore. Okay? Because it's too, what we call it, something that is beyond me. Last but not least, I would give this, okay, as my conclusion that to me the regulatory framework provided in terms of achieving the maqasid is there. Dr. Aida have listed down a very good points in terms of how IFSA's requirement and the key features of IFSA complement the maqasid. Okay? So I'm not going to add on that. It is a good study, it's a good, what we call it, area for us to look at. But other than that, the challenge on us, the moving forward is that we should develop ourselves. Okay? I'm not talking about us as individual, but us as a team, as all the stakeholders in Islamic finance. And then when we talk about the stakeholders in Islamic finance, okay, we are talking about the regulator, the Sharia Committee, the management, the financial industry, and also the consumer. Okay? These are the factors that we must understand. We must understand. I'm giving that what we call it, examples on the theory, which this theory was presented by Professor Engku Rabiah Adawiyah years back, 1990s. These are basically the aspect of which, for us to know about Islamic finance, these are a simple thing that we must understand. Understanding the full objective of the Sharia, what Sharia is all about in the context of accounting, commerce, trade, finance, and whatnot. However, after 40 years, we are still struggling with this. Okay? And then the fact that when can we achieve a full maqasid? I would say it's a continuous journey. It's a continuous journey. We can't be expecting that after 40 years, we definitely reach at the peak of it and then no more work after that. No, it's ongoing work. It's ongoing work in progress, I would say. And then who should be working is us, individual. Rather than looking, oh, it should be regulator, it should be Sharia Committee only. No, all of us. okay, all of us. So it's a big challenge. When I look at it as well, there's a lot of aspect that I still yet to understand, but let us struggle and then move forward, at least have a good understanding of all this. Okay? So thank you very much. Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh.
Thank you, Dr. Rosni. It's a kind of a wake-up call for all of us, the stakeholders of the industry. In fact, it's also a déjà vu for me when she said something like, every time a new legislation been enacted, the practitioners will say that, wow, again? Because when I was practicing as an accountant, as an auditor, every time the accounting standards been amended, we used to ask ourselves, don't they have better things to do than to amend the accounting standards? And they keep on amending the standards. They change the terminology from provision of dark debts into impairment or those kind of things. But towards the end of the day, we see there are objectives of doing such thing. Okay, moving forward. As discussed, or rather we say that much has been said and discussed about Maqasid al-Sharia. Why are we harping on this Maqasid al-Sharia? When I started to be involved in the industry, it was when Bank Islam Malaysia, that's a clear indication that I'm old. Maqasid al-Sharia was never mentioned. Nobody talks about Maqasid al-Sharia. And why are we talking about it now? Well, basically, having done my research, is that it is indeed one of the most important concepts that play a crucial role in strengthening the contemporary Islamic banking today. And some scholars also say that it is considered as a measurement to streamline the Islamic banking activities along with the different products offered in the market. As you can see, more and more new products being introduced, more and more structures, the combination of different contracts. Speaking from experience as a rating agency, we tend to occasionally get confused with the combination of all sort of contracts to come out with a simple wakalah sukuk. Okay, moving forward, and then again, I would say that to further discuss on this, I'm pleased to introduce Associate Professor Dr. Siti Farida Abdul Jabbar of UKM, who will share with us her thoughts on the implementation of Islamic banking in the light of Maqasid al-Sharia. Associate Professor Dr. Siti Farida Abdul Jabbar is an Associate Professor in Law at the Faculty of Economics and Management, University Kebangsaan Malaysia. She was basically a guest lecturer at the London BPP School of Law from 2008 until 2010, lecturing on subjects relating to Islamic finance and financial regulation. On that note, please welcome Dr. Siti Farida.
Bismillahirrahmanirrahim. In the name of Allah, most gracious, most merciful. Mr. Chairman, distinguished guests, ladies and gentlemen, Assalamu alaikum and a very good morning. First of all, I would like to extend my heartfelt gratitude to the organizers of this conference for inviting me to this august event. I am indeed very honored and very humbled to be here today as well as yesterday. And I'm also very fortunate that there was a change in the speaking plan by inviting Dr. Rosni before me and by having Dr. Aida before me. It has made my work much, much, much easier. So I've less responsibility on my shoulders, but it could be also a disadvantage to me because now I'm left with nothing to say. So perhaps just to make sure that I have something to say, before I start with my presentation proper, I just would like to ask one question, particularly to the male audience here. Why is it that men love football so much? Please bear with me for a moment for asking this seemingly irrelevant question. But yes, why do men love football so much? I must admit that I was pretty dumbfounded when I first saw 22 men who are sober but crazily chase after this lifeless round object. And sometimes these men would get into fights over this lifeless object. And these fights include the infamous headbutt, shoulder biting. I wondered and wondered and wondered, why is it that men love football so much? And after a lot of wondering, one fine day, I finally come to a realization that men are crazy about football because there are rules that regulate the game. Yes, because there are rules. Imagine if there are no rules in football. Imagine if there is no such thing as offside. There is no such thing as penalty kick. I just want to show off some of my football knowledge. Imagine if there is no clearly defined area in which to play the game. If there is, or if goals may be scored into any goalpost. Would football be interesting to watch and to play then? Precisely, I don't think so. Therefore, I've come to the conclusion that men are crazy about football because there are rules, there are laws that regulate the game. Law is therefore very important in football. Yeah, law has a very huge impact on football. But I'm not here to talk about football. Yeah, don't worry. I know I'm no Shabby Singh or Abbas Sa'ad. Instead, I'm here to talk about the role of law in realizing Maqasid al-Shari'ah in Islamic banking. And again, I'm very fortunate because Dr. Aida, she has succinctly explained what Maqasid al-Shari'ah is. And as for me, I'm not a Sharia expert. I do not have any Sharia background. It's very helpful what she has done. And for me, I always like to take the easy way out. So in my, from what Dr. Aida has presented, I deduce that different Muslim scholars give different interpretation to Maqasid al-Shari'ah. But although that is the case, all the definitions lead to one common meaning of Maqasid al-Shari'ah, and that is the noble and higher objectives of the Islamic law. And in relation to economic activities such as Islamic banking, it simply means that Islamic banking is to be carried out according to Islamic teachings and Islamic principles. And based on that notion, we have Islamic banking that is devoid of riba, gharar, maisir, and other haram elements. And at the same time, Islamic banking is to, I don't know why I'm so nervous all of a sudden. I mean, I wasn't nervous when I was talking about football. So it means that Islamic banking is not only to be devoid of riba, gharar, and maisir, but it is also to be commercially viable so as to bring about economic wealth and economic prosperity. So in short, Islamic banking is to achieve socio-economic objectives where economic growth, economic prosperity, efficiency, stability, integrity, social welfare, and social justice go hand in hand, which would ultimately lead to the attainment of spiritual health. And as what Dr. Aida mentioned earlier, and as well as what the first speaker and the second speaker yesterday, Dr. Mustafa and Mr. Rafiq, respectively mentioned, whatever that promotes maslahah, i.e. well-being, and whatever promotes mafsadah, and whatever avoids mafsadah or harm is Maqasid al-Shari'ah. And in Malaysia, the Islamic Financial Services Act 2013, which came into force on the 30th of June last year, does to a certain extent attempt to realize Maqasid al-Shari'ah in Islamic banking. And this is evident in the principal regulatory objectives of the Islamic Financial Services Act, which are to promote financial stability, to protect the rights and interests of consumers of financial services and products, and to ensure Sharia compliance. And to achieve these objectives, the Islamic Financial Services Act, for example, imposes a statutory duty or a legal duty on Islamic financial institutions to ensure that the aims, operations, affairs, businesses, and activities are Sharia compliant. Again, to reiterate what Dr. Aida and Dr. Rosni said earlier. However, the question arises, what does compliant with Sharia means? Well, it means compliance with any ruling of the National Sharia Advisory Council. This is provided in the Islamic Financial Services Act, which stipulates that compliance with any ruling of the National Sharia Advisory Council shall be deemed to be compliance with the Sharia. However, ladies and gentlemen, it is in my humble opinion that the definition of Sharia compliance as stipulated in the Islamic Financial Services Act is somewhat limited. And why do I say this? This is because the current rulings of the National Sharia Advisory Council are not exhaustive. The rulings, in my humble opinion, do not encompass many aspects of Islamic commercial jurisprudence, what more of Sharia principles in general that would help fully realize Maqasid al-Sharia in Islamic banking. The reason I say this is because the rulings of the National Sharia Advisory Council mainly relate to the design, operations, viability, and validity of financial products, financial services, and financial transactions that revolve around the avoidance of riba, gharar, maisir, and other haram elements, but there is a lack of emphasis on matters that relate to, for example, Islamic economic behavior, Islamic economic trusteeship, equitable distribution of wealth, and social welfare. Ladies and gentlemen, if we have a look at the Islamic Banking Act, which has been repealed by the coming into force of the Islamic Financial Services Act, we would see that the old Islamic Banking Act provided that the aims and operations of the Islamic banks are not to involve any element not approved by the religion of Islam. This definition of Sharia compliance in the old Islamic Banking Act was wider than the definition of Sharia compliance under the new Islamic Financial Services Act, which, as I've mentioned earlier, is more limited. One could only assume that the change in the definition of Sharia compliance is to avoid the repetition of the ramifications that the Malaysian Islamic banking industry went through after the decision of the High Court in the case of Arab Malaysian Finance Berhad versus Taman Ihsan Jaya Sdn Berhad, where the High Court decided that the requirement not to involve any element not approved by the religion of Islam as to mean not to involve any element not approved by all the mazhabs of Islam. And based on that interpretation, the High Court decided that the transactions entered into by the Malaysian Islamic banks with their customers that were based on the contract of Buy Bithamin Ajil were not Sharia compliant because although it is approved by the mazhab Shafi'i, it was not recognized by the other mazhabs. And as all of us know, that decision caused a ruckus in the Malaysian Islamic banking industry, despite the fact that High Court's decision had been overruled by the decision of the Court of Appeal. And perhaps, I'm just assuming, perhaps with that incident in mind, the definition of Sharia compliance is now narrowed down to compliance with the ruling of the National Sharia Advisory Council. Understandably, this is to have more certainty and to avoid further complications for the Islamic banks. However, in my humble opinion, the narrowing of the meaning of Sharia compliance would not help to fully realize Maqasid al-Sharia in Islamic banking. But perhaps we could establish a middle ground where the National Sharia Advisory Council could issue more rulings, particularly relating to equitable circulation of wealth and communal economic welfare that would help further realize Maqasid al-Sharia in Islamic banking. And perhaps Dr. Rosni is thinking, well, she can easily say that because she's not a Sharia scholar. Please don't be too serious. Okay, although having said all that, the move taken by Malaysia via the Islamic Financial Services Act to elevate the rules governing Sharia compliance from merely guidelines to statutory duties or legal duties must be highly commended. This is particularly because Islamic banking does exist in a number of countries that have inferior regulatory infrastructures. In some countries, even where there are laws that are passed to regulate the activities of Islamic banking, those are merely expansions of conventional banking regulations. And in some countries, the Islamic banking industry is left to self-regulate. Some regulators merely ignore the value-added element of Sharia and merely consider whether the proposed Islamic banking business conforms to the requirements of the existing conventional law. So despite the incomprehensiveness of the definition of Sharia compliance in the Islamic Financial Services Act that would help fully realize Maqasid al-Sharia in Islamic banking, Malaysia still deserves a pat on the back for its unwavering effort to have a more comprehensive legal infrastructure for Islamic banking. Ladies and gentlemen, another aspect of the Islamic Financial Services Act that attempts to realize Maqasid al-Sharia in Islamic banking relates to consumer protection, where the Act introduces the establishment of the Financial Ombudsman Scheme to ensure effective and fair handling of complaints and to resolve disputes in connection with financial services or products. I must say that this is a move in the right direction because many court cases have demonstrated that litigation in the civil courts is not the most suitable forum in resolving disputes relating to Islamic banking. Besides, Islam does not favor litigation in resolving disputes. Although litigation as a form of dispute resolution is recognized in Islam, the Quran and Sunnah are replete with preferences for amicable settlement. Islam strongly advocates amicable settlement in settling disputes that is based on an equitable, fair and just manner which results in justice and a win-win situation. In Islam, dispute resolution is not merely an interhuman activity, but it has a divine connotation as well, where it is regarded as an act of worship to Allah. Those who uphold a just, fair and amicable dispute settlement will be handsomely rewarded by Allah, if not in this world, in the hereafter, as mentioned in Surah An-Nisa, verse 114 of the Quran. And to illustrate how an Islamic amicable dispute resolution mechanism may be utilized in resolving business disputes, let me take you to the United States, where the Islamic amicable dispute resolution mechanism of mediation, or suluh, is used among certain groups of the Muslim community in that country. In one case, there were two Muslim individuals who entered into a business dispute. Who entered into a business deal, and later, that's when my mind goes faster than what I'm saying. Okay, there were two Muslim individuals. They entered into a business deal, and later they were in a dispute over the deal. And these two individuals approached an imam, and they asked the imam to decide what each of them was entitled to with respect to the business deal. And once both parties agreed to be bound by the imam's decision, the imam asked both parties to present their evidence, and then the imam decided what each party was entitled to. But before the signing of the final agreement, the imam reminded both parties that his decision was only as good as the evidence that the parties had provided him. And the imam also said that had any party given him false testimony, Allah would know, and that person would be held accountable on the day of judgment. And suddenly, one of the party, he started to cry, and he confessed that he had actually provided inaccurate information, and he said that he was not entitled to a portion of the sum that was awarded to him. And the other party was so moved by his honesty that the party decided that he could keep the original amount as awarded by the imam. So, ladies and gentlemen, we could see from this case, an initially bitter dispute had become an amicable settlement through the use of alternative dispute resolution mechanism. And to illustrate another advantage of using an alternative dispute resolution mechanism instead of litigation in courts, let me take you to another case involving a company from India and a company from Kuwait. The parties in this case entered into the Islamic contract of manufacture, i.e. istisna, and the contract stipulated that the transaction was to be governed by the laws of England, but subject to the Sharia. In other words, if there is a conflict between the English law and the Sharia shall prevail. And the contract also stipulated that should there be any dispute between the two parties, the dispute would be brought for arbitration, instead of litigation in courts, and the place of arbitration would be London. So when the case was brought for arbitration in London, the arbitrator, who is an expert in Sharia, he awarded the principal and profit claims because both claims are allowed not only under the English law but also under the Sharia. But the arbitrator refused the claim for additional damages because although it would be allowed under the English law, but it would conflict with the Sharia. And again, from this case, it is evident that an alternative dispute resolution mechanism is more suitable than litigation in the civil courts where Islamic financial transaction is involved. Therefore, the introduction of the Financial Ombudsman Scheme is indeed a laudable move, because Financial Ombudsman Scheme is also a form of alternative dispute resolution to litigation in the civil courts. Further, ladies and gentlemen, the effort to realize Maqasid al-Shari'ah in Islamic banking is demonstrated in the Islamic Financial Services Act via provisions that not only regulate Sharia committees, but accord some statutory protection as well to the committees. The Sharia committees, which were previously lightly regulated, are now statutorily regulated with a more extensive regulation, and these would help enhance the integrity of the Islamic banking industry. And upholding integrity, as I mentioned earlier when I talk about Maqasid al-Shari'ah, is indeed part of Maqasid al-Shari'ah. And to see the correlation between the regulation of Sharia committees and the enhancement of the integrity of the Islamic banking industry, perhaps it is best illustrated by us looking at some other jurisdictions where Sharia committees are left unregulated, and consequently concerns have arisen over several matters. As we are aware, Sharia committees are remunerated by Islamic financial institutions to advise the institutions on aspects relating to Sharia compliance. At the same time, Sharia committee members act as religious auditors of the Islamic financial institutions. In jurisdictions where Sharia committees are left unregulated, the fact that the Islamic financial institutions may select and dismiss a Sharia committee member, and the fact that the Islamic financial institutions may decide on the remuneration of a Sharia committee member, all these facts have raised concerns about the possible creation of a conflict of interest situation, concerns about the independence of the Sharia committee in arriving at its decision, and concerns about the integrity of the Sharia committee's rulings. And after saying this, it reminds me of what happened exactly 2 weeks ago in one particular country, where the Assembly of Muslim Jurists in that country, which is a non-profit organization and comprises of Muslim scholars with doctorates of philosophy in various Islamic sciences, together with 230 local imams, have ruled that Muslims in that country are not to deal with two particular Islamic financial institutions in that country. Why? Because the Assembly of Muslim Jurists found that the financial products offered by these two Islamic financial institutions are not Sharia compliant. And at the same time, the Assembly of Muslim Jurists ruled that the financial products of another 4 Islamic financial institutions contain some Sharia violations. So we can see that we have this Assembly of Muslim Jurists, which is a non-profit organization and which has a huge influence on the Muslim communities in that country, rule that the financial products are not Sharia compliant or contain some Sharia violations, despite the fact that the Sharia committee of the respective Islamic financial institutions have authenticated the Islamic financial products as Sharia compliant. So at one end, we have the Assembly of Muslim Jurists, who rule that the financial products are not Sharia compliant, and the Sharia committee of the Islamic financial institutions who authenticated that the products are Sharia compliant. So one need not wonder the impact of this, not only to the integrity of the Sharia committee's rulings, but unfortunately also the integrity of the Islamic financial services industry as a whole. And further, after reading that report, it came to my mind, what if the customers and investors of the Islamic financial institutions suffer any loss because of the conflicting Sharia rulings, and they decide to take legal actions against the institutions? In my humble opinion, the customers and investors have the legal right to do so, not only under the civil law, but under the Sharia as well. In fact, I humbly submit, under the Sharia, the customers and investors who have suffered loss or any damage may also take legal action against the Sharia committees, regardless of whether the loss or damage is major or minor, and whether or not the Sharia committee has motive to cause the loss or damage. In my humble opinion, under the Sharia, the customers and investors may sue the Sharia committee for damages, compensation, or other remedies for the loss or damage that the Sharia committee's rulings has caused. I further humbly submit that under the Sharia, it is also immaterial that the Sharia committee's ruling is not a criminal offense under the law in force, since what is being upheld here is the private right of an individual, i.e. al-haq al-shahsi, that is recognized in Islam under doctrine of daman or damages, which applies to cases where a defendant commits an act, i.e. al-ta'adi, that causes injury or damage, i.e. darar, to a plaintiff. Well, I'm not an expert of Sharia, as I mentioned earlier, so I would welcome response, particularly from the Sharia experts, whether my opinion is valid or otherwise under the Sharia. But fortunately, after telling that sad story, fortunately in Malaysia, those concerns that I mentioned earlier are somewhat put at bay. For example, the requirement in the Islamic Financial Services Act that prior written approval of the Bank Negara is required in the appointment as well as the termination of Sharia committee members by Islamic financial institutions, hopefully gives assurance to market participants and instill confidence in them that any Sharia rulings issued by the Sharia committees are arrived at impartially and not impaired by any monetary inducement. Furthermore, in Malaysia, the duties and functions of the Sharia committees are set out in standards issued by the Bank Negara. Failure to fulfill the duties and functions could entail in severe penalties in the form of fines and imprisonment, as well as removal as a Sharia committee member by the Bank Negara, again, as what Dr. Aida and Dr. Rusni has mentioned earlier. And this reflects the commitment of Malaysia in ensuring that Sharia committees truly perform the functions of a steward or gatekeeper on behalf of investors and the community at large. Ladies and gentlemen, previously, the Sharia committees were not accorded any statutory protection, but now under the Islamic Financial Services Act, the Sharia committees are accorded with a statutory right to be provided with accurate, timely, and complete information by the Islamic financial institutions. Dr. Rosni did point out the importance of this, but I would like to elaborate further by saying that it is vital that the Sharia committees are given timely and complete information by Islamic financial institutions to ensure that the Sharia committee could fully perform its duties and functions as required by the law. Because the capability of the Sharia committees to perform its duties and function also hinges on the financial institution's openness in transmitting to the Sharia committee full and accurate information which are pertinent for the Sharia committee's deliberations. Ladies and gentlemen, perhaps you have heard that in some jurisdictions, a few financial institutions fail to disclose all relevant information to the Sharia committees. And at times, this entails in misguided judgments on the part of the Sharia committees, since their decisions are arrived at based purely on the information given to them by the institutions. And related to this predicament is the mischief of some financial institutions that only adhere to Sharia compliance during the approval stage, but discreetly ignore or abandon the Sharia compliance requirement during execution or actual transaction. Obviously, in such a situation, this places an unnecessarily heavy burden on the Sharia committees because they have to be constantly on guard so as to ensure that the requirements of the Sharia are complied with, not only at the proposal or approval stage, but right until post-transaction. In short, Sharia committees need to constantly audit transactions from pre to post-execution. In Malaysia, that kind of predicament is curtailed, if not avoided, by the Islamic Financial Services Act, imposing a legal duty on Islamic financial institutions to disclose all relevant information to the Sharia committees. At the same time, the interests of the Islamic financial institutions are legally safeguarded because the Islamic Financial Services Act also imposes the statutory duty of confidentiality on Sharia committees, where the committees shall not divulge the information the committees receive from the Islamic financial institutions to any other party other than the Bank Negara as required under the law. In my humble opinion, this is a commendable move because it enhances mutual respect between the Sharia committees and the Islamic financial institutions. Ladies and gentlemen, apart from the Islamic Financial Services Act, in Malaysia, we also have the Sharia governance framework issued by the Bank Negara. According to the framework, a Sharia committee member shall not be an employee of the Islamic financial institution and shall not be a member of another Sharia committee of another Islamic financial institution within the same industry. For example, an individual shall not be a member of two Sharia committees of two different Islamic banks. Such a prohibition, however, does not apply where the institutions are from different industries, example, banking, takaful, and capital market. Therefore, an individual may become a member of a Sharia committee of one Islamic bank and one takaful company, for example. The prohibitions are to ensure independence and to avoid the possible problems of undue influence, conflict of duties, and breach of confidence, which are concerns in some jurisdictions where multiple appointments of Sharia advisors are not regulated. And after having said this, it also reminds me of another incident. I have a lot of incidents to tell, but I don't think I have enough time, so I'll just share another one. It reminds me of an incident that occurred on the 2nd of February 2008, where I attended a conference on Islamic finance overseas. And during a forum at that conference, there were more or less 10 panelists, and I sought the opinion of the panelists about concerns that have been raised regarding possible problem of conflict of duties, where Sharia advisors are not regulated, particularly where multiple appointments of Sharia advisors are not regulated. And the response that I received from the panelists was, I should say, overwhelmingly negative and hostile. Even after the forum ended, we had a break for tea, and when I was on my way for tea, one of the panelists came up to me and told me off and said, "You should be more concerned about your own kind." And until today, I'm wondering what does he mean by my own kind? Am I different from everybody else? Well, but I guess that partly explains the reason why, even until today, in some jurisdictions, there is reluctance to regulate Sharia advisors, unlike in Malaysia. Ladies and gentlemen, the Sharia governance framework that I referred to earlier also stipulates that no member of a Sharia committee of an Islamic financial institution may be appointed from the members of the National Sharia Advisory Council of the Bank Negara. Again, this is unlike in some other jurisdictions. And this also reminds me what the moderator earlier this morning mentioned. He said, I think his name is Paul, sorry if I don't remember your name. He mentioned that he doesn't understand why is it that, we tend to be busybody or nosy, or we want to have a look what happens in the backyard of our neighbor. Well, I think we're not being nosy or busybody here, but rather we are being concerned about what's happening, in the backyard of, in our neighbor's backyard, particularly when it comes to financial services industry, including Islamic financial services industry, because in the financial services industry, what happens in one country, what happens in one jurisdiction, what happens in one region would have an impact in other jurisdictions, in other regions. So for the sake of integrity, for the sake of stability, we have to be concerned about what happened in our neighbor's backyard. And coming back to the Sharia governance framework, it provides that the Sharia committee shall observe the published Sharia rulings of the National Sharia Advisory Council in coming up with its Sharia decisions. In fact, every decision of the Sharia committee shall be approved by the National Sharia Advisory Council before the decision is to be given any effect. All these have the positive impact of creating consistency and uniformity in Sharia rulings. Consistency and uniformity in Sharia rulings are crucial so as to ensure that the Islamic financial products, instruments, or services offered by the various Islamic financial institutions would meet the religious standards of all groups of Muslim investors, thus giving the investors the certainty and assurance that their investments comply with their religious beliefs. These, in turn, would culminate in confidence in the integrity of the Islamic financial services industry, thus helping to realize Maqasid al-Sharia. Furthermore, the issue of lack of transparency in Sharia rulings and authentications is put to rest in Malaysia by the Bank Negara documenting and publishing the Sharia rulings. The task is shouldered by the Bank Negara, as it is not advisable for each Islamic financial institution in Malaysia to publicly publish the rulings of its Sharia committee for the sake of standardization and to avoid confusing the public with publications of possible conflicting rulings. So ladies and gentlemen, we have seen how the law plays a crucial role in helping to realize Maqasid al-Sharia in Islamic banking. However, the law would be more effective when there is an added dimension to the law. The added dimension comes in the form of religious belief and religious commitment. This is evident during the first few centuries of Islam, where economic activities that were guided by faith, i.e. Iman and Aqidah, were imbued with morality and ethics, i.e. Akhlaq. Adherence to the Islamic principles and values created strong business institutions and a market economy that was founded on justice and fair competition. Muslim merchants even traveled to foreign lands and were welcomed in the foreign lands, and they conducted successful trades in various countries. In a relatively more current environment, the effectiveness of internalizing Islamic principles and values into one's activities had been empirically studied by a number of management researchers. The empirical study done by A.J. Ali, for example, found that the internalization of Islamic concepts strengthened certain qualities, and the qualities include honesty, trust, solidarity, loyalty, and flexibility. Another empirical study conducted by T. Fort found that business leaders with religious convictions have a stronger motivation to conduct business ethically, although it is not financially profitable to do so. Further, El Guiso and a few others investigated the relationship between the intensity of religious beliefs and economic attitudes and discovered that on average, religious beliefs are associated with good economic attitudes and better institutions. They also remarked that religious people are less willing to break the law, and further found evidence that religious upbringing and affiliation curb the willingness to break the law. Therefore, to reiterate, laws do have an impact in realizing Maqasid al-Sharia in Islamic banking. But simply having laws that merely rely on legalistic prescriptions of permissible and forbidden acts would not be as effective as having laws that are supported by religious belief and religious commitment. Ultimately, in my humble opinion, what has to be borne in the mind of all participants of the Islamic banking industry is that Islamic banking should not merely be a profit-driven industry, but it should also be a faith-driven one where morality, ethics, social justice, and other noble and higher objectives of the Sharia are given due regards. Ladies and gentlemen, thank you very much for your kind attention. Assalamu alaikum.
Thank you, Dr. Siti Farida. I just realized that she is basically a consultant to the International Compliance Group, a global compliance advisory firm based in Washington, D.C., United States. Therefore, that explains how she can actually relate the external or foreign cases to here. Just that I'm still contemplating, I'm still trying to analyze how she relates Maqasid al-Sharia with football. On that note, I would like to invite Ustaz Burhanuddin Luqman, who is basically a lecturer of Kuliah Undang Ahmad Ibrahim International Islamic University in Malaysia. He is also a member of the Sharia Advisory Council of Bank Negara Malaysia. And on that note, please welcome Ustaz Burhanuddin Luqman to comment on Dr. Siti Farida's paper, not so much on the football case. Thank you.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله والصلاة والسلام على رسول الله وعلى آله وأصحابه ومن والاه وبعد. Ladies and gentlemen, Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh, and a very good morning to everybody, or maybe it is now afternoon. Thank you for inviting me, to the organizer, Bank Rakyat, to share my thoughts in this very esteemed conference. Although being a substitute, as mentioned by Dr. Rusni just now. I'm here to give a few comments on the presentation by the respectable Associate Professor Dr. Siti Farida Abdul Jabbar. I found that her presentation was really enlightening and very comprehensive. But how I wish all the presentations were put in the paper earlier so that I can give quite thorough comments on that. But I think it is strategy. What I can say here that I can agree on most of the parts that she presented just now. It's very good presentation, very comprehensive. Only on a few parts why male are crazy about the ball. I have no answer about that. I'm not crazy myself about the ball, about football. And she mentioned about financial ombudsman, amicable settlements. My comment is that the details of the procedures in Sharia are left to the people to decide. It depends on the interest of the people of that time to decide on the details of the procedures, whether to bring it to the court or to the arbitration and to elsewhere else. And on the uniform, whether to choose a uniform Sharia rules in a country or to adopt a system that is left to the respective Sharia committee. Both are available in the world today. In Malaysia, we choose to uniform the rules, and in most of the countries in the rest of the world, they choose to leave it to the respective Sharia committee to decide. I personally prefer what we are doing right now in Malaysia, that we sort of uniform the rules, but on condition that we should not go to the very details of the rules. The respective Sharia committee should be left with some independence to decide. Actually, I also prepare. My strategy is to prepare for a few slides to add some values to this session. Because I said earlier, the paper was not presented to us earlier. So what I would like to share with you with regard to the regulating or regulators as well as the Sharia committees in the country. So for me, regulators should play a big role, and they have crucial role in both in implementing maqasid Sharia and also in ensuring maqasid are implemented by the people. Without going into the details of IFSA, I would like to take the audience to the basic foundation of this notion, of this concept. Allah subhanahu wa ta'ala says in the Quran, وَجَعَلْ لِي مِن لَدُنْكَ سُلْطَانًا نَصِيرًا. In order to his prophet to do this dua to Allah, and grants me from you, God, a helping authority, power. Sultan in Arabic does not mean sultans of these days. It originally means a power and authority. And Ibn Kathir, in interpreting this verse, elaborates about the need of power and authority to ensure the implementation of truth. He further says, in Arabic, I just quote here, لا بد مع الحق من قهر لمن أعداه وناوأه. ولهذا قال الله تعالى, and he brings the ayah and the verse from Surah Al-Hadid, mentioning three elements that a deen needs. لقد أرسلنا رسلنا بالبينات وأنزلنا معهم الكتاب والميزان the second thing. ليقوم الناس بالقسط وأنزلنا الحديد فيه بأس شديد. And he also mentioned another hadith from Uthman, إن الله لا يزع بالسلطان ما لا يزع بالقرآن. I just quoted from the translator, which I don't really agree with the translation. He said, alongside the truth, he also needed power. Actually, I believe that the more correct translation should be the truth. For here, where Ibn Kathir mentioned, لا بد مع الحق من قهر لمن عاداه. It should be translated, the truth needs power and authority in order to suppress those who oppose and resisted it. And that is why Allah said in the ayah that I read just now, indeed we have sent our messengers with one clear evidences and sent down with them the scripture and the balance. And the third thing, that people may maintain their affairs in justice, and we send down iron. So it should be come together, three elements. We need evidences, the Quran is there, the scripture, the Bayina, the Rasul, and the third thing is the iron, the power, the symbolic of power. And as mentioned by Ibn Kathir, he mentioned narration from Uthman, which says, إن الله لا يزع بالسلطان ما لا يزع بالقرآن. أي لا يمنع الله بالسلطان عن ارتكاب الفواحش والآثام ما لا يمتنع كثير من الناس بالقرآن وما فيه من الوعيد الأكيد والتهديد الشديد وهذا هو الواقع. Which means Allah, by using power, will be removing the evil which the people do not refrain from just by using the Quran. Which means that Quran alone is not enough to eliminate the evil. And Quran must work hand in hand with power and the authority. Ladies and gentlemen, apart from the power, let me bring you to the human nature, the very human nature which strongly loves wealth. As mentioned by Allah, وَتُحِبُّونَ الْمَالَ حُبًّا جَمًّا, and you love wealth with immense love. وَإِنَّهُ لِحُبِّ الْخَيْرِ لَشَدِيدٌ, and indeed he is in love of wealth, intense. And a lot more other verses in the Quran. And all the economists are agreeable upon this concept. The surplus units, those depositors and investors will forever prefer a guaranteed return for their deposits, for their investments. They do not want to take the risk. Hence, if the people are left with their own choices to choose, people will not do all the good deeds if they are left to choose by themselves. For example, usury and interest. People all over the world before Islam and until now still perceive, especially the unexcessive. It is subjective otherwise. Unexcessive interest is good to the economy. I don't need to prove to you. All over the world, this is the perception, and this is what they teach their students. And revocation of usury of Al-Abbas, the Prophet said during Hajjatul Wada, which occurred in the 10th years after the Hijrah, which is the very last moment of the life of our Prophet. Riba al-Abbas mawdu', I revoke now the usury that was practiced by my uncle, Al-Abbas. So until that very last moment, even though Al-Abbas is a very noble person, but he was still practicing usury until the last moment of Islam, last moment of the life of the Prophet. Same goes to sex before marriages. Two willing parties. They don't harm anyone. They take all the precautions to mitigate the risk. Yeah. And human has no ability to know everything that is beneficial for them in a bigger picture. That is why we have to follow the order from the Quran and the Sunnah, and that's why the authority should come. For example, in Islamic finance, we often hear, it's not here, we often hear that people say, we will let the Islamic finance prove itself. Let the people themselves choose, either Islamic finance or conventional. Let the market drive its own path. It is market driven. For me, the authority and political will is needed to eliminate all the evil, including riba and usury. So in answering whether IFSA is enough or comprehensive enough and perfect, yes, I believe it is quite comprehensive, but nothing is perfect but Allah and His book. A lot more to do in this regard. Let me share with you another slide. I'm not sure how many minutes left. I got several other slides. Sharia will not contradict maslahah and maqasid. I don't want to elaborate on this further because of time limit. The role of Sharia committee in light of the maqasid. I think this is quite relevant to our presentation just now. So the Sharia committee, being one of them, me, myself, we, or the Sharia committee members, should take into their account both the Sharia text and maqasid together. You cannot separate this is according to maqasid. You should also, before looking at the maqasid, you should study all the Sharia text from legal forms point of view and from the substantial point of view. And the Sharia committee also have to apply Sharia and maqasid together from end to end, from the starting to the end of the products, at both macro and micro level, from structuring the products to the sales of the product, the purpose why the product is introduced to the customers. Yesterday we heard someone said that the important thing is to look at the maqasid at the end, at the sales point, not the structuring point. But I tend to disagree with this idea. You have to look from the very beginning whether the underlying contract itself is based on maqasid, whether the contract that we are going to use, for example, ijara, al-bay', whether we meet the maqasid of al-ijara, whether we meet the maqasid of al-bay' in this product, whether we meet the maqasid of the prohibition of riba in this very product. And the role of Sharia committee also to safeguard the interests of both parties, not just the IFIs, because they are paying them the retainer and as well as the intensive or incentive fees and whatnot. So there should be independence and balance between the interests of the customers as well as the IFIs. Just to bring you a few examples in structuring the products, how to ensure that the maqasid is done. Firstly, we need to ensure no riba, no excessive gharar or maisir, darar, and no contradiction to Sharia text, no mukhalafat nusus. These 4 elements should be preserved, and including forms and substance. No mention of interest explicitly, and the most important part that some of us might neglect, no interest in disguise. No interest under the name of bike. I can see someone smiling. And the maqasid from the prohibition of interest should be achieved. This is a challenge. It is enlightening to hear that many people, and more people start talking about maqasid, in implementing maqasid. But on the other hand, what frightening me and worrying me that to really understand maqasid is quite a challenge. For me, maqasid sharia is of the highest level of knowledge of sharia. Someone has to have extensive and exhaustive reading of sharia, and then he knows why is this particular rules is given by Allah subhanahu wa ta'ala. Many people can speak about 5 elements in maqasid. Hifz al-din, hifz al-mal, hifz al-nafs, hifz al-nasal. But how to apply these elements in very specific tashri'. For example, the tashri' of buying. For example, the tashri' of prohibition of interest. How to protect wealth by prohibiting interest. What is the wisdom behind that? This is a challenge. So the maqasid of buying must be achieved. And this is the challenge to the Sharia committee. The sale must be genuine and not fictitious. Must have all the effects of true sale, whether the forms and the substance. The true sales should comprise of true asset and generate production as well as produce. There must be true transfer of the asset as well as the liability. True movement of money. What about INA? What about organized tawarruk? I leave it to all the Sharia committees to decide. I must disclaim that I'm not representing SAC or Banagara. I'm wearing my individual hat today. It's quite contentious whether the tawarruk is organized, whether we can allow organized tawarruk, even at the very highest level of authority in this country. The purpose of sale must be compliant. For example, tawarruk, the sales at the sales point. I think this is very clear. Another example in Ar-Rahnu. I don't want to touch a lot about this because it might be sensitive here. Sorry, organizer. But just to share with you my thoughts. So Ar-Rahnu, in my humble opinion, is comprised of 2 elements. Money lending, it is based on qard, as well as Ar-Rahnu, as security. Normally they use gold, the al-marhun. So the court, in the Islamic point of view, from maqasid point of view, should not have any element of material benefit to the lender. Qardun jarra naf'an is not allowed. And al-marhun, the security, the charge, or the chargee, the murtahin cannot take any benefit from it except up to the actual expenses borne by him. Hence, this product should not be profit-generating product. I'm also sitting at one of the Sharia committee in cooperative, Rakyat Koperasi. They intended to introduce this product, Ar-Rahnu, because they said other people can make a lot of profit out of Ar-Rahnu. I asked them, what do you want from this product? You want to help the needy? Yes, go on. I will support you 100%. This is the very purpose of Shara, maqasid Shara. But if you want to make it as a profit-generating product for you, no. This is not meant to be profit-generating because it's comprised of qard and security, and rahan. So, which maqasid should be considered? Helping the needy through the product, or the maqasid of qard and rahan from the very beginning? So, I leave it to you to decide. I think this is the last slide from me. And thank you for listening.
Thank you, Ustaz Burhanuddin. Well, speaking about riba in disguise as bay', I thought as a conventionally trained people in the Islamic banking industry thought we are facing the same problem. Whereas if Ustaz Burhanuddin, being a Sharia committee member, also face the same predicament, well, I think we are in the same boat. Okay, I know you have some burning questions to ask these distinguished presenters, discussants. Unfortunately, I've been instructed by the organizer not to open for any question and answers. It's not my decision, it's the organizer's decision. Okay, however, I hope the panel speakers, panel presenters will be around for lunch and try to get hold of them, or even while they are walking down the stairs, please get hold of them to ask you questions. Okay, on that note, on behalf of the organizing committee, I would like to thank our distinguished presenters as well as discussants for being able to be with us today to discuss and to share the experience, the knowledge in terms of, in relation to this Maqasid al-Sharia. And at the same time, on behalf of, at the same time, I would like to thank the organizing committee for inviting me to be part of this interesting and eye-opening discussion. On that note, wabillahi tawfiq wal hidayah. Wassalamu alaikum wa rahmatullahi wa barakatuh.